Hello, everyone. Welcome to a sunny Saturday morning. I'm sure everyone is feeling great. It's 10 a.m., so everyone should be ready to learn. The next topic is Precharge Advocacy. This is a really interesting topic with lots of differing opinions. It can be complicated and probably the scariest part of our job sometimes. Luckily, we've got three experienced professionals to help us here. Scott Fenton has an extensive experience in criminal, quasi-criminal, regulatory, and professional discipline matters, trials and appeals, white collar, you name it, he's done it. Mr. Fenton has appeared at all levels of court, including the Supreme Court of Canada. Michelle Psutka practices with Scott Fenton. She has appeared as counsel in all levels of court in Ontario, Nova Scotia Court of Appeal, the British Columbia Supreme Court, and as intervener in the Supreme Court of Canada. And I think she's the only lawyer I know in recent history to do anything positive with an extradition case. Tam Bui is a retired police manager from Toronto. In his policing career, Mr. Bui has worked major crimes and on joint force organized crime wiretap teams. He's heard your conversations. As a surveillance and investigative sergeant, Tam concluded his policing career as a detective staff sergeant, managing one of 6 homicide teams. Tam owns Strike Consulting, a full-service private investigation agency. So welcome to our panel, and I look forward to this.
Are we on? Yep, we're live.
I'm not on. Hello?
Hello?
Okay, great. Thanks, Adam. To start, do we have our PowerPoint? Oh, I can't see it. Okay. So, all right. Really, I mean, like most cases, when you're in a pre-charge situation, every case is different. Not every step that we're going to talk about today is going to be appropriate in every case. There's a lot of common pitfalls and landmines involved when you're trying to advocate to not have your client charged. So it's really an area where if you're in doubt at all, it's an area where you should contact senior counsel for advice if you're ever unsure. And we only have half an hour today, so to the extent that we can't cover some topics today, please have a look at our paper and the materials. And all of our emails are also on the last slide of the PowerPoint. If you have any questions after the presentation, we're all happy to take some questions. So, the first thing we want to talk about is preparing your client if you anticipate that they're going to be arrested, preparing them for what will happen when they're arrested. Why is preparing your client for this so important, Scott?
So a lot of what we're going to say I would describe as basic advice, but really, really important advice, and the senior criminal lawyers in the room will know all these points, but they bear repetition because the time when your client is most vulnerable is before arrest. And I'm going to go through a couple of scenarios which will be familiar to all of you, I hope. But the default position should always be no statement, right? And I always say to clients, sophisticated, unsophisticated, here's why. You don't know what they know. You're in an informational vacuum, so first. Second, even if you're honest, even if you're innocent, you can make mistakes. Those mistakes may be interpreted as lies. And third, a statement that's self-serving of your innocence is probably not even admissible. So there's no upside and huge downside. Don't make a statement. The trick is in drilling that into the client's head, because every criminal lawyer in this room has probably had a situation where they've given the advice, do not speak to the police, and then 3 weeks later you get the disclosure and you're like, what the? And there's a 10-page statement videotape. So what I do, if you have the luxury, this is 2 scenarios. One, you know the client already and an arrest is imminent so that you can prepare. And that's the ideal situation because first of all, you know your client, you know whether the client is stupid, the client is not stupid, or the client thinks he's smarter than you and everybody else, right? Because those are all problems. So what I think is important, and you cannot take too little time doing this, is going through all those reasons why you shouldn't give a statement. You need to make a client understand that anything, any word spoken other than this is my name and my age and this is where I live, is a statement. You know, like too many people just watch too much TV and think, oh, well, you know, I'm not on videotape, I'm just talking to the cop in the back of the car. Everything's a statement. So it's really important to prepare that client. I think it's important to prepare the client for the types of tricks that will be played on them by police officers once, you know, even if you go to the station with them, once they're taken into the back, that they will say, well, you know, okay, you don't want to talk. Let us talk. And of course, what they're trying to do is get a conversation going. Or, well, you know, we really, our hands are tied unless we have your side of the story. All these, you know, kind of arguments that are meant to appeal to common sense of a non-legally trained person, right? So you need to be able to get the client briefed on all those types of tricks so they're able to withstand them. One good trick, I think, is if you're able to, give the client a little card that says on it, on the advice of counsel, I do not wish to make a statement. Maybe it's the back of your business card if you can do it. And have them have it with them, because at least it's a little, you know, a blanket that they can hug. Beyond that, I would say just with the interactions with the police, if you learn that the client's being hauled in for an arrest and a statement, get as much information as you can regarding the case, the charge, the circumstances, address bail, release issues, get as much information there as possible so that while your client's in, you can take steps to get a surety and get a bail plan going. Last thing I would say is, in all cases, on a planned arrest, do not take your phone, right? Leave the phone at home and don't bring any other digital devices. Just show up with your ID. And I think if you can do that with your clients and make most advantage of that one shot you have with the client, right? Because it's often just one shot, one chance, the client will do fine.
Just to add to that, a couple things may be obvious, but the reason that you don't want your client to have their phone on them when they if they turn themselves in, is police can seize that incident to arrest. Now, you might want to let your client know that the police are not always going to nicely ask their lawyer or leave a message on their phone asking them to turn themselves in. They can show up at any time and arrest your client. And in that scenario, you'll want to let your client know at least that they're not compelled to give the police the password to their phone. So even if the police sees it, they'll maybe have a hard time getting into the phone. And another thing is, if your client is imminently going to be arrested, I like to tell them to screen any unknown numbers, just in case that's a police officer calling them, asking them to turn themselves in. I'd rather that go to voicemail, and then I, as counsel, can call back so the client's not unexpectedly having a conversation with a police officer on the phone. Anything else to add about the scenario? It's a little bit outside of pre-charge advocacy, but when you get to help turn your client in, you can prepare. Is there anything else to add, Scott, about when you don't have that time and you just get the call from the station, you've never spoken to the client before?
Yeah, so that's the second scenario, and that's by definition more challenging. You don't know the client, or maybe you do, but more likely you don't know the client. So you don't know the client's intelligence, capacity to understand, legal sophistication, and again, one shot, right? Unless you can get down to the station, and if it's a very serious charge, that would be position A. Get down, get in the client's face, have, you know, eyeball to eyeball conversations with the client to try to convince them that they should not make a statement under any circumstances. Otherwise, I would, on the phone, take the time to go through all the things I've already said and, you know, and ask for the client's understanding, right? Do you understand that, like, if if you talk, there's a good chance you're going to make life a lot more complicated for yourself. As George Finlayson once said to me when I was arguing an appeal, all fish get hooked by the mouth. And it's true. So
I'm stealing this from a paper that Liam O'Connor wrote. It's really great. I think it's in 2 parts, but about that initial advice to your client. And one thing that sometimes sticks in their head, if nothing else does, is that if they talk, their case is going to be more expensive. Just picture dollar bills coming out of their mouth if they're giving a statement, because that's more time that you have to review it, possibly try to get it excluded. So sometimes if all else fails, the money talks. Now, what can we advise clients, Scott, if perhaps it's a project case or a type of case where you think there maybe is going to be a search warrant coming at your client's house or office? What can we tell clients in advance about what to do if that happens?
So I think the basics of how to respond to search warrants, particularly where you get a call, hey, the cops are at my business or my house, they're executing a search warrant, are as follows. Remind the client that a search warrant is a presumptively valid court order and they are duty-bound to comply unless it has some glaring defect on its face, such as the wrong house or wrong date. Ask to speak to the officer in charge as soon as possible. Ask to get a copy of the warrant and read it carefully. You can try to attend on the premises. I've done that before. You tend to be sort of stuck out in the lobby, but at least you can have face-to-face with the client. Really importantly, go over with the client and employees, if they're there, that while the police have the right to search, they don't have the right to interrogate you, and you may wish to exercise your right to silence. Don't give statements, just comply with the police. I think increasingly these days, where everything's digital, right? So all search warrants have a digital component, a VU-compliant digital component. They're going after computers, phones, and other digital devices. The first question to the client has to be, are there privileged materials on any of these devices? And the same would go for paper, too. And where that's the case, it's really important for counsel to have a direct conversation with the arresting officer, seizing officer, to say, my client informs me there's solicitor-client privilege or litigation privilege materials here, here, and here. You must seal these devices. And then get that to the officer, like get the officer's email. There may not be a Crown yet involved. Is a Crown involved? Get the Crown's contact and write both and put that in writing, because they are duty-bound to seal it, and they can't look until a court rules otherwise. But really important to do that like right away, right, before they start sniffing around on stuff.
A couple other quick considerations. If you think your client's facing a very serious charge, again, maybe it's a project investigation or something like that, consider whether they may be subject to a wiretap authorization. And you may want to advise your client to be very careful about what they're speaking about or to on their phone, in their home, in their office. Physical locations can have devices on them as well, not just phones. Equally, again, it may be obvious, but I think especially probably with younger clients, it might not be, and you'd be best to advise them not to post anything about the incident on social media. Now, one pitfall to consider that's very important is if your client knows that they're under criminal investigation, you as counsel should make it very clear to them that getting rid of or destroying evidence of any kind when they know they're under investigation would constitute obstruction of justice. And you just want to make sure that you have written documentation somewhere of you making that very clear to them. So we're going to move on to conducting your own investigation, where, if you're anticipating your client may be charged and you want to secure evidence or documentation that would be helpful to the defense, you want to get on that right away, and time is really of the essence. You do not have to wait for the client to be charged to start doing these investigations and securing some of this information. So just one consideration in when you're securing evidence directly from your client is making sure that if it's on their phone or some kind of digital device, that you're getting it extracted from the phone, or telling the client, make sure not to delete that. You want the original copy of it. Like, you want to be able to prove its authenticity, that it hasn't been tampered with. And in that sense, you probably don't want to be a witness yourself to the extraction. So if you have the budget, it's often a good idea to retain a forensic computing company. There's lots of them. You can just ask other lawyers who have used them, where they can do the extraction. So if anyone ever has to testify that this documentation from your client is original and hasn't been tampered with, they can do that instead of you or your client. Now, one pitfall, perhaps I'll just ask you about it, Scott, and then we're going to turn to Tam for some of his insights on investigations. What about if you find out in the pre-charge context that your client might have physical incriminating evidence?
Yeah, so on the one hand, you have to advise the client, don't destroy or delete anything because you're at risk of obstruction of justice. On the other hand, if you do collect information from the client or things from the client, you have to be wary of whether or not you've acquired, material evidence that's incriminating. So, you think immediately of Ken Murray's case and the ordeal he subsequently went through. So, happens, I would say, less often. It certainly has only happened to me once, but I think you got to turn your mind to that. I mean, are you in possession of some video that's incriminating that the police would want? Have they sought it and missed it? That's what happened in Bernardo. So you just have to turn your mind to those issues. And if you're concerned at all, I would say this: if you're concerned at all that there could be an issue, go get independent legal advice. In other words, don't take a chance on being wrong.
So some other parts of an investigation that you might want to do, again, when time is of the essence, you are anticipating a charge coming, is getting evidence from third parties, maybe testing your client's alibi, or investigating witnesses or who you anticipate to be the complainant. So Tam, as an experienced retired police officer and now private investigator, what are some of the things for counsel to consider in that context?
Well, I mean, certainly my role pre-charge is much more limited. I'm generally brought in after the fact to do investigative work, looking into someone's background, but I have been brought in a number of times to help prep someone who's going in for an interview, even just to explain logistically in the nuts and bolts. This person's never been arrested before. All of a sudden there's a very serious, sex-related or family intimate partner violence charge. What's going to happen when you roll in the doors of the police station? So just sometimes giving them that operational layout of what's going to happen to them when they're arrested is very helpful on making sure they follow Scott's advice before going in. In terms of evidence, you should be aware that the retention of certain records has really changed over the last few years. So in my experience, we are hired to go out and canvass for video a lot. And I would say that high definition video is lasting maybe 10 days to 14 days after the event. So if your client wants to make the decision to fund something like that, or if it's in your mind, you have to pull the trigger really quick to actually retain that evidence. Now, if a building is a condominium, there could be bylaws that change the retention level, but small mom and pop stores, generally you're looking at 10 days. Adam and I learned in a case a few years ago that Rogers and Bell, the big carriers, have also changed the retention of their cell phone records. So, before the police, we used to write production orders and get the entire history from Bell of a cell phone life. They're now looking at Rogers is 12 months and Bell is 13 months. And then the information they claim is gone forever, and no court order will get that back. This is different. If there's a wiretap up and running, along with the wiretap, there's a DNR that's recording all those calls and that contact and the SMS and to some extent digital messages, but not very many. So if you're interested in cell phone records, you have to get that demand letter out to the telco very quickly because you might not know of the number at the beginning of your investigation. And that certainly cuts both ways. It means that it's unavailable to you and your client, but it's also unavailable to the police and the state after 12 or 13 months.
Yeah, and that's a consideration as well if you have to get evidence from third parties by subpoena through the court, then you should consider before you actually get the subpoena. You send the preservation letter out right away, but before you actually get the subpoena for the documents, you'll want to carefully consider whether they're actually helpful, because most of the time those are going to end up in the Crown's hands as well. Now, aside from not wanting to be a witness yourself as defense lawyer, what other reasons are there, Tam, where it's good to use a private investigator when you're investigating witnesses or an alibi or anything like that?
I mean, we're brought in, so there's two levels of investigations. You can, as a lawyer, you can hire an individual private investigator. So private investigators are restricted, are regulated by the Solicitor General. They are only allowed to work for a law firm, an insurance agency, or another investigative agency. My recommendation is to hire an agency. I own an agency. There's many other options in Ontario. Agencies are allowed access to certain licenses that an individual investigator does not have. For example, agencies are allowed access to Ministry of Transportation records, so everyone, not everyone, I have an MTO account. That's very helpful when doing backgrounds or trying to locate people. Agencies are allowed access to credit information. That was restricted back in 2023, but still, that's a very robust database. And then also use a firm that knows how to get into the criminal courts and run searches through ICON and do a proper background on your complainants or people that have an ancillary involvement into your case. Not all agencies understand the ICON system. Not all clerks understand the ICON system, that it is meant to be public, and the access to it is very restricted in certain courthouses. And then there's obviously interview prep that we might do, and examining people's phones, documenting information depending on what their budget is, to have it forensically examined.
I would just add one thing as counsel, where you retain a private investigator, is know what is being done, know what techniques are being used, and make sure you're satisfied they're lawful and they're ethical. And you know, if you hire Tam, you're not going to have those concerns. But you know, I've had a case where, you know, we had to back off certain techniques that were being used. We were concerned, you know, particularly social media searches. So just a note to file there.
So now we're at the stage where maybe you're considering providing documents to the police or providing a statement to the police. I think, Scott, you'd probably agree it's generally pretty rare that you're doing this before a charge is laid, but in some cases it may be appropriate. So one thing to consider is that ensure that anything you're handing over to the police, especially if it's text messages or social media messages from your client that may demonstrate, that may be exculpatory, that they're not infringing on any third-party privacy interests. After the case of Maraca 2017 Supreme Court, which held that people have a privacy interest in messages they send to other people, you have to consider that before you just hand over text messages to the police, because they'll need to get, if it engages someone else's privacy interest, they'll need to get a warrant before that can be used, and you just want to avoid that. There are some scenarios where, you know, perhaps it's a conversation with someone who's friendly to your client and it's exculpatory, and maybe you can get a waiver from that person of their privilege, of their privacy interest before you hand that over to the police. But that's just something to consider in that regard. There's more to say about that. You can check out our papers. We're running out of time. Scott, what things should be considered before you send your client in to give a statement to the police before they're charged?
Yeah, so although the default position is don't make a statement, there will arise special situations where it's advisable for the client to go in. In my view, those are cases where it's demonstrable that the police are wrong and your client is innocent, and you may be able to go in and clarify the matter. But you have to be really sure. I had one, I won't bore you with it, but it was just no question the right thing to do was to get that client in and explain that he was in Hamilton, he's got proof he was in Hamilton, he wasn't anywhere near Toronto, he had nothing to do with the assault. So I think those are the simple cases. With the time left, I'll just add this. There can be much more complex scenarios where you want to be sharing information with law enforcement. For example, if you know there's an advisory crown involved, or like pre-charge crown, or you're dealing with the Ontario Securities Commission, where they may have they may invite you to make submissions through a Wells letter, before making a final charge recommendation, or a tax evasion case with the CRA, where you may have an opportunity to make submissions, whether or not they give you the special investigations report. But those are cases, situations where there are opportunities for pre-charge advocacy, and that can include sharing information, including trying to stave off a warrant, because, as everybody knows, that ITO becomes public, it could be devastating to your client's reputation, right, if it's in the front page of the Globe and Mail. So always think of whether you have those opportunities for pre-charge advocacy. It's tough to do it with just the police, but there are situations where that is available.
Just for the last topic, I'm going to skip the media statements. Most of the time your cases aren't going to have media interest, but you can see our paper for very strict rules around what you can say and the pitfalls that you should be aware of. But I wanted to go over protecting your client in parallel proceedings because I'm sure the criminal system interacts with other systems all the time, particularly family proceedings. Sometimes if the charge involves a car accident, there's insurance proceedings and depositions. And so many times I've had a case where, for whatever reason, I was not made aware of a deposition happening, and the client didn't assert their rights under Section 13 of the Charter, also Sections 5 and 9 of the Ontario Evidence Act and the Canada Evidence Act that protect any kind of deposition or statements or discovery in another parallel proceeding about the same conduct that you anticipate might be resulting in a criminal charge. So just make sure that if you have a client where they're anticipating there may be a charge and there's another proceeding, that you're in touch with the counsel in the other proceeding, and you're making sure that the client's taking all steps to protect the later use of evidence in that proceeding and the criminal charge against them. So we've been told to wrap it up, but again, see our paper for more details, and if you have any questions about anything we've talked about today or any other scenarios, our emails are here. Feel free to contact us. And again, when it comes to pre-charge advocacy, when in doubt, get senior counsel advice, if that's one takeaway we can have today. Thank you.